Article 14 provides for equality before law. Article 15 prohibits discrimination against citizens. And Article 16 provides for equality of opportunity in public employment. Clause 1 of Article 16 declares that there shall be equality of opportunity for all citizens in matters of employment or appointment to any office under the state. This article applies only to citizens. Equality of opportunity is available only to citizens. Here we are talking of equality of opportunity, not about equality of employment itself. And this equality of opportunity is in respect of public employment only, employment under the state. Clause 2 of Article 16 prohibits discrimination in public employment. It declares that no citizen shall be discriminated against in employment or office under the state on grounds only of, and then there are these 7 grounds are given: religion, race, caste, sex, descent, place of birth and place of residence. In clause 2 of Article 16 there are 7 grounds. In Article 15 in clause 1 there were 5 grounds. 2 more grounds have been added here: descent and place of residence. There shall be no discrimination against citizens in employment or office under the state on these grounds only. So clause 1 and clause 2, they lay down rules for equality in public employment, and thereafter in clause 3, clause 4 onwards, we find those provisions which provide for a preferential treatment in certain cases. Clause 3 of Article 16 says that Parliament may by law make residence within a state or UT a condition for employment or appointment to an office under the government of that state or that union territory. So there can be a preferential treatment to those persons who are residing within the state or within that union territory in respect of public employment in that state or that union territory, but such preferential treatment can be given only by a law which can be made only by the Parliament. The state legislature cannot make any such law giving special treatment or preferential treatment to its own residents. And then comes a very important provision which deals with reservations in initial appointments. This is clause 4 of Article 16. It is an enabling provision. Similar provisions were there in Article 15 also, in the form of clause 3, clause 4, clause 5 and clause 6. Here also we have this enabling provision. First of all, in clause 4, which says that this article, that is Article 16, does not prevent the state from making a provision for reservations in the matter of appointment in favor of a backward class of citizens which is not adequately represented in services under the state. Now here there are many points to be carefully noted. Firstly, this clause talks about reservations in appointments only. Second, it talks about reservations in favor of a backward class of citizens. What is meant by a backward class? That is a moot point and that has not been answered here anywhere in our constitution. And the third important point to be noted is that such a reservation in appointment can be made only if that particular backward class is not adequately represented in services under the state. This clause does not provide for any reservation. This is important to note. This clause by itself does not provide for any reservation. It only enables the state to make a reservation if the state so wants. It neither prevents a reservation nor provides a reservation. It permits the state to provide for a reservation if it so wants. And then if the state decides to provide the reservation, then Article 16 will not come in the way, provided this reservation is only for initial appointments. This is only for a backward class of citizens, and that backward class of citizens should not have adequate representation otherwise. The Supreme Court delivered a momentous judgment on this clause of Article 16 in 1992 in the case of Indra Sahni versus Union of India. Several questions were raised in this case, and the Supreme Court gave categorical answers. We'll be dealing here only with a few important questions and their answers. Question 1. Whether Clause 4 of Article 16 is an exception to Clause 1. Clause 1 says that there will be equal opportunity for all citizens in matters of public employment. Equal opportunity for all citizens. This is what Clause 1 provides for, but Clause 4 of the same article says that there can be reservations in favor of a backward class of citizens. So as far as those seats or those posts for which reservation is provided to a backward class, the other people cannot compete, and therefore there will not be equal opportunity for employment in respect of those posts or those seats which have been reserved. So do we say that Clause 4 of Article 16 is an exception to Clause 1? The Supreme Court says no. Clause 4 is not an exception to Clause 1. Rather, it is an instance, it is an illustration of the classification which is inherent in Clause 1. The Supreme Court declares that classification is inherent in Clause 1 itself. Though on the face of it, Clause 1 says that there will be equal opportunity for all citizens, but actually it is not so. Classification is inherent in Clause 1. So Clause 1 itself allows or permits classification in favor of certain classes. And Clause 4 just provides an illustration of such classification. This reservation is in favor of a backward class of citizens. Similar reservations can be provided for other classes of citizens also. In Clause 4, reservation is for a backward class. There can be reservation by the same logic in favor of other classes of citizens also. Question 2. Whether Article 16(4) is exhaustive of the concept of reservations in favor of backward classes. Now this is a natural question arising from the answer to the first question. If Clause 1 itself allows or permits reservations in favor of any class, then can we say that apart from the reservation provided to a backward class under 16(4), there can be more reservation in favor of a backward class under Clause 1 itself? The Supreme Court says no. As far as backward class of citizens are concerned, the reservation provided to them under Article 16(4) is exhaustive. There can be no more reservation in their favor under Clause 1. So, as far as backward class of citizens are concerned, what 16(4) provides is exhaustive. But yes, under 16(1), reservation can be provided in favor of other classes. Then question 3. Whether Article 16.4 is exhaustive of the very concept of reservations. Whether clause 1 of Article 16 does not permit any reservations. And this question is already answered earlier. Reservations can also be provided under clause 1 of Article 16. This is a very, very important and profound statement of law given by the Supreme Court in respect of clause 1 of Article 16. It says, reservation can also be provided under clause 1 of Article 16. So, essentially there was no need of clause 4. Clause 4 provides reservations in favor of the backward class of citizens. The same thing could have been done under clause 1 also. So in a way, clause 4 is superfluous. But now that clause 4 has been introduced in Article 16, therefore, as far as backward classes are concerned, they cannot go beyond clause 4. But clause 1 is open to every other class of citizens. And this reservation is not confined to extending of repressions, concessions or exemptions alone. It can be in other forms also. Issue 4. What is the meaning of the expression backward class of citizens in Article 16.4? A very important question. Since clause 4 of Article 16 provides reservations only for backward class of citizens, and since this term has not been defined or explained anywhere in the Constitution, so this question needs an answer as to what is meant by this expression, backward class of citizens. Which class is known as backward? What is the criterion for determining whether a given class is backward or not? The court says a caste can be and quite often is a social class in India. Now, two different terms are used and I am emphasizing both the terms. I have put them in bold. A caste and a class. The court says that in India, a caste is quite often a social class. And if the caste is backward socially, then it would be a backward class for the purposes of Article 16.4. This is as far as Hindus are concerned. But as far as non-Hindus are concerned, how do we determine the backwardness? As far as Hindus are concerned, if the caste is backward, then it will be termed as a backward class also. As regards non-Hindus, the backwardness can be determined by the occupation they are pursuing. The court observes that there are several occupational groups, sects and denominations which for historical reasons are socially backward. And these occupational groups represent backward social collectivities for the purpose of Article 16.4. So, a reservation can be provided amongst non-Hindus also in favor of such occupational groups which are backward for historical reasons. Question 5. Should creamy layer be excluded from this reservation? And the answer is yes. And not only yes, the court emphasizes that not only creamy layer can be excluded, creamy layer must be excluded. If the creamy layer is not excluded, then the reservation cannot be provided to the whole class or to the whole caste. And the next important question is, what can be the extent of this reservation under 16.4? To what extent can the reservation be made? Whether the 50% rule which was enunciated long back in 1963 in Balaji case is a binding rule or only a rule of caution or rule of prudence. And the answer is this. The reservations contemplated in clause 4 of Article 16 should not exceed 50%. So the norm is that the reservation should not exceed 50% under clause 4 of article 16 in favor of backward classes. But it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of this country and the people. Which means, in certain extraordinary situations, this reservation can go beyond 50%. And how far beyond 50%? That again is not clear. But yes, at least theoretically, there is a permission that it can go beyond 50%. And then here is the last question. Whether clause 4 of article 16 provides reservation only in the matter of initial appointments, or does it provide for reservations in promotions as well? And the answer is again very categorical. The court lays down that article 16 clause 4 does not permit reservations in matters of promotions, which means it provides reservations only in the matter of initial appointments.